Patentability of Software in the USA, 2014. After Alice Corp. Versus CLS Bank International. The United States Supreme Court has recently made a decision on software patents. Alice Corporation versus CLS Bank International, June 19, 2014. The patent claims recited methods of exchanging obligations between parties, data processing systems, and computer-readable media containing a program code for directing an exchange of obligations. Representative method claim. A method of exchanging obligations as between parties, each party holding a credit record and a debit record with an exchange institution. The credit records and debit records for exchange of predetermined obligations. The method comprising the steps of A. Creating a shadow credit record and a shadow debit record for each stakeholder party to be held independently by a supervisory institution from the exchange institutions. B. Obtaining from each exchange institution a start-of-day balance for each shadow credit record and shadow debit record. C. For every transaction resulting in an exchange obligation, the supervisory institution adjusting each respective party's shadow credit record or shadow debit record, allowing only these transactions that do not result in the value of the shadow debit record being less than the value of the shadow credit record at any time. Each said adjustment taking place in chronological order, and D. At the end of day, the supervisory institution instructing one of the exchange institutions to exchange credits or debits to the credit record and debit record of the respective parties in accordance with the adjustments of the said permitted transactions, the credits and debits being irrevocable, time invariant obligations placed on the exchange institutions. Lower court decision. In the Federal Circuit, a 10-member en banc panel released 7 different decisions. None of the opinions garnered majority support. 7 of the 10 judges agreed that the method and computer-readable medium claims lack subject matter eligibility. 8 of the 10 concluded that the software patent claims should rise and fall together regardless of their claim type. Supreme Court used Mayo framework. The Supreme Court used its earlier decision in Mayo Collaborative Services versus Prometheus Laboratories, Inc. as a framework. Using this framework, the court must first determine whether the claims at issue are directed to a patent-ineligible concept. If so, the court then asks whether the claims elements, considered both individually and as an ordered combination, transform the nature of the claim into a patent-eligible application. Application of Mayo Framework Part 1. The Supreme Court stated that the software patent claims at issue are directed to a patent-ineligible concept, the abstract idea of intermediated settlement. Application of Mayo Framework Part 2. The function performed by the computer at each step, creating and maintaining shadow accounts, obtaining data, adjusting account balances, and issuing automated instructions, is purely conventional. In summary, a software patent in which conventional steps are computerized is not statutory. Where do we go from here? The United States Patent and Trademark Office has issued preliminary guidelines for examination of software patent applications and other patent applications after the Supreme Court's decision in Alice versus CLS Bank. Examiners are to use Mayo Framework. Examiners are now to analyze all claims, product and process, having an abstract idea, using the following two-part analysis set forth in Mayo. Part 1. Determine whether the claim is directed to an abstract idea. And Part 2. If an abstract idea is present in the claim, determine whether any element or combination of elements in the claim is sufficient to ensure that the claim amounts to significantly more than the abstract idea itself. Examples of abstract ideas: fundamental economic practices, certain methods of organizing human activities, an idea of itself, and mathematical relationships formulas. If the claims include abstract ideas. Claims that include abstract ideas like these should be examined under Part 2 to determine whether the abstract idea has been applied in an eligible manner. Examples of limitations that will work. The guidelines provide the following non-exclusive examples of limitations that may be enough to qualify as significantly more when recited in a claim with an abstract idea: improvements to another technology or technical fields, improvements to the functioning of the computer itself, and meaningful limitations beyond generally linking the use of an abstract idea to a particular technological environment. Examples of limitations that will not work. The guidelines provide the following examples of limitations referenced in Alice Corp. That are not enough to qualify as significantly more when recited in a claim with an abstract idea: adding the words "apply it" or an equivalent with an abstract idea or mere instructions to implement an abstract idea on a computer, and requiring no more than a generic computer to perform generic computer functions that are well understood, routine, and conventional activities previously known to the industry. For software patent help, contact Deepak Malhotra, registered United States Patent Attorney. He has more than 20 years' experience in patent preparation and prosecution and has followed the development of software patent law since the beginning. For additional information, you can go to his website at www.patentsusa.com. This website includes examples of software patents, or to www.softwarepatentsusa.com, and this website provides a history of software patent law in the United States.